Hello, ladies and gentlemen, welcome to Coin Lady channel. And I have to say that a good portion of the story made me laugh out loud. You're probably all aware that there's been a lawsuit against Ripple for about half a decade, alleging that XRP is a security. The SEC versus Ripple case is not the one I'm referring to. I'm referring to the class action suit filed against Ripple in 2018. There's a big hearing today. Zach's case is strong enough. This may have already taken place by the time you read this. Once I have more information, I will release a new video updating everyone on the situation. But I will say this much. A small group of plaintiffs assert that they have suffered financial losses due to Ripple and that XRP is a securities. The fact that lawyer John Deaton jumped in to defend over 76,000 XRP holders who say otherwise is funny. The certification of the class action lawsuit against Ripple is the subject of today's hearing. If you were the plaintiff's attorney in this case, how would you feel if you had a small group of clients who needed the extra security, and then 76,000 people came in to say, "Oh, no, BenQ is wrong like that"? That's so funny it hurts. So let me quickly go through this. To be quite clear, though, I do not have any sort of legal or financial backing at this time. Neither legal nor financial counsel is being provided by me. And remember, you should never use anything I say as a reason to buy or sell something. Just a hobbyist here that occasionally posts films to YouTube on various crypto-related topics. And now for some extremely quick background information. When the news first broke almost 10 years ago, this was one of the headlines that covered it. This is the headline from CoinDesk for Friday, June 8, 2018. According to court documents, investor Gladys Echo filed a class action lawsuit on Tuesday, naming Ripple Labs XRP to the company's licensed money services business CEO Brad Garlin and 25 anonymous persons as defendants. The suit claims that XRP is a security and seeks unspecified damages from the company. The action was filed in the Superior Court of California and the County of San Mateo. It alleges that Zach Enough bought XRP in January 2018 and suffered losses due to the claim that the XRP token is a security managed by Ripple. This has always struck me as the most ridiculous assertion. The true inspiration has always left me wondering. As a group, we have entertained theories on the matter. I won't even claim to know the answer, but here's how I see it working out. In this case, this individual here. I'll look it up on the video, but I think somebody said later that he held XRP for a while. However, I estimate around 2 weeks. If you anticipate to make money off of Ripple's work, which is at least part of what the consideration entails, how can you possibly hold Ripple responsible? You'd have to keep the asset for longer than 2 weeks if you wanted to make any money off of it, you moron. So, once again, I can't say that I've ever found it convincing. The lawsuit that claims XRP is a security now has a public hearing date, according to a headline in today's Crypto Basic article. Class certification hearing. That case, including economics and the ripple effect, will be heard later today. Crypto Law, a US-based legal and regulatory news service, claims. The court hearing is scheduled for today at 4:30 p.m. Eastern Time in a federal court in California. In all likelihood, by the time I get this up, this will have taken place. I hope to continue this conversation. We'll see how things develop. If this doesn't pass certification, though, it may be over. From what I gather, that service will be terminated. Curiously, the judge has only allowed 500 members of the public internet access, and they must participate in the proceedings via a login notification supplied by crypto legislation. A paraphrase of, there will be oral arguments at the hearing on whether or not the class of XRP holders suing Ripple should be certified. In this action, according to Bradley Sustak, who believes that XRP is a security and wishes to be the lead plaintiff on behalf of John Deane's crypto organization, XRP is a security. In addition, he hopes to speak for all XRP holders, whether they are now holding the cryptocurrency or have already sold it at a loss. Let me be honest with you, I have no idea what you people are like. Maybe I have heard of you before. I don't want to have this guy stand in for me in any capacity. Besides the fact that his XRP has nothing to do with mine, he also has no clue as to why I or anybody else has XRP. Damages have been claimed for 2 weeks. Like a bratty brat for acting like a fool. If you're going to try to speak for me or the rest of the community, just know that you're in the minority among anyone who has ever bought XRP. No comparison can be made between a few humans and the roughly 76,000 people who are represented by DT. Continuing the piece, prominent U.S. defense attorney James K. Yle made the announcement on Twitter, writing, "In the Sustak case in California, there is a hearing on class certification tomorrow. See below for an announcement and explanation from the inventor of crypto law and attorney John Dean on this development." He represents thousands of XRP holders as amicus curiae and wrote that yesterday. Attorney Deaton claims that a friend of the court involved in the US SEC's action against Ripple has indicated that he will participate in the hearing remotely. Even if the court agrees to hear the amicus brief, he or she will not enable amicus lawyers to take part in oral arguments. He characterized the change as a long-standing precedent of the court and said it would have no bearing on the case. According to prior reports, in the litigation, Deaton sought permission to submit an amicus brief on behalf of more than 75,000 XRP holders. The judge has not yet decided on his motion. The progenitor of crypto law begged the XRP community to keep out of the courtroom and to avoid contacting the plaintiff or the ripples involved in the case. Therefore, that is sound counsel indeed. I believe I have the tweet pulled up here. I just didn't feel comfortable telling you that. This is what John Deaton actually wrote, word for word. You may recall that throughout the pre-trial proceedings and the SEC versus Ripple case, public phone lines were made available. Remember that there were initially a large number of these people, perhaps 100 or so, but that number quickly dwindled. I forget if it was an increase of 2,000 or 4,000, Amendment 2000, but shortly Doug realized we needed extra capacity. Massive capacity expansion is the point, though. And you were welcome to phone in. There was usually a waiting list for those, and they filled up rapidly. However, Zoom is required here. So, I doubt that everyone is as likely to do it as you may think. And it's possible this isn't getting as much attention. I can't say for sure if it will reach its limit. You have to do that, you can't just phone him. I mean, I kind of believe the answer is going to be yes, because so many people have Zoom these days. Consequently, that would be a cool thing to see. However, Attorney Deaton unexpectedly planned to attend and tweeted the following: "Please know that I intend to be on Zoom." However, even if an amicus brief is permitted, this judge does not let amicus lawyers to join in oral arguments. The court has always followed this practice. Therefore, it is irrelevant to this investigation. I anticipate that people will be primarily listening. Please refrain from interfering with the New York hearings in any way, including contacting Ripple attorneys, plaintiff attorneys, the court, or anyone else connected with the matter. You are strictly forbidden from making any kind of communication with anyone involved in these instances. Don't even think about it. You are not authorized to do this, and even if you were, you wouldn't be assisting anyone. No doubt about it. I also recall that during an earlier pre-trial hearing in the SEC versus Ripple case, someone yelled, "XRP to the like, don't get sounds hilarious." This occurred in either the First or Second Amendment. But don't be a jerk about it. It's possible that after XRP to the moon was spoken at the end of one of the pre-trial sessions, everyone went into listening mode. But at first, no, you could have genuinely entered. People will be able to hear you until you use the mute button. Then someone else added their 2 cents. In particular, I love the ending. So, XRP community member and legal expert Fred Rispoli gave his thoughts on the matter. And this is just one more way of showing how awful things are for the plaintiff's lawyer. Recently, his lawyer told me, "You want to talk about dealing with the unexpected as a plaintiff's class action lawyer. That is, having another plaintiff lawyer come in representing 75,000 of your proposed class and smash your class certification motion, the most essential move in class action lawsuit." Yep. What is happening on this motion today is, therefore, the most crucial aspect of this course. That, then, is the reality they are facing right now. Again, you have a small group of people that claim to speak for the rest of the XRP community, and then you have over 75,000. I don't see how this is going to work, especially since you're being defended by Attorney God, and I just don't see how it works. Shouldn't this economic gang just put this to rest after today? I mean, I hope that's the case. However, I can't say for certain what will occur in this situation. But, my goodness, what bizarre occurrences! Being on the side of history's winners feels nice, no. Being on the right side of history is great, I agree. Okay, I guess I should wrap this up. An update will be available at some time. So, I'll be covering this topic in an upcoming video. I'm aware, but for the time being, this is the situation. I don't give advice on money matters. Nothing I say should influence your buying or selling decisions. And in the end, please like and subscribe my channel as always. See you in the next one, bye.